Chapter 5. Charitable Trusts. Key Exam Issues. When the facts of an exam question set forth a trust with an apparently charitable purpose, do not immediately assume that you have a charitable trust. It is important for you to make a determination of whether the trust is in fact charitable. This determination may be important because the correct answer to your question may turn on the special privileges accorded only to charitable trusts, or the trust's very validity may depend upon its purpose being classified as charitable. Your initial task, then, is to determine that the trust meets the requirements of a charitable trust, namely, whether it has I. A public benefit, and Roman 2. A charitable purpose as defined by law. 1. Public benefit. There must be an indefinite number of potential beneficiaries. If there are inseparable private benefits, the trust may fail as a charitable trust. 2. Charitable purpose. Check first to see whether the purpose falls within one of the generally accepted categories of charity, i.e., relief of poverty, advancement of education or religion, promotion of health, or governmental or municipal purposes. If the objectives of the trust do not fall into a specific charitable category, consider whether the purpose, e.g., perpetual care of graves, is sufficiently of interest or beneficial to the community to justify permitting the property to be dedicated to its accomplishment. Note that an established category, e.g., educational purposes, has a fair amount of stretch, and broader purposes, e.g., public interest, are fairly open-ended. Remember, even if a trust purpose seems to be charitable, watch for some particular basis for disqualification, e.g., private benefits. 3. Cypres. If a trust seems to have outlived its original charitable purpose, analyze whether it can be modified under the doctrine of cypres. There are 3 obstacles or steps to deal with in attempting to apply the cypres doctrine. A. Has the specific purpose been accomplished, or become illegal or impracticable? Or are the trust funds excessive for the specified purpose, so that adhering solely to that purpose would fail to utilize the funds, or would be objectionably wasteful under cypres standards? Remember that under standard doctrine, it is not enough to convince a court that the funds could be better used for another charitable purpose. B. Did the settlor have a general charitable intent? Or did the settlor intend for the fund or excess to revert by resulting trust to the settlor or her successors in interest, if the specified purpose was accomplished or became impossible? The mere fact that the settlor directed the funds to be used only or exclusively for the specified purpose is not determinative. C. If the preceding hurdles are cleared and cypres is to be applied, consider what purpose or modification should be selected under the trust terms and the underlying motives and circumstances of the gift. A. General nature and treatment of charitable trusts. 1. Creation and purpose of Trust 502. A charitable trust is created in the same manner by will, inter vivos transfer, or declaration as a private trust, but such a trust is established for a purpose that the law regards as charitable. It is a trust, the performance of which will, in the view of the law as interpreted by the courts, rather than merely in the opinion of the settlor, confer appropriate benefits upon the public, or upon some reasonably broad and appropriate segment thereof. Rest. 3D28. 2. Charitable purposes 503. The third restatement lists the following purposes as charitable. I. The relief of poverty. Roman 2. The advancement of knowledge or education. Roman 3. The advancement of religion. Roman 4. The promotion of health. V. Governmental or municipal purposes. And Roman 6. Other purposes that are beneficial to the community. Rest. 3D28 and CUTC 405A. 3. Charitable trusts favored 504. Charitable trusts are favored by the law and are accorded special privileges not given to private trusts. They are generally construed in a manner that serves to uphold and preserve them, i.e., to limit the purposes to those that qualify as charitable, and they are exempted from some of the restrictions applicable to private trusts. B. Requirement of public, not private, benefit. 1. Indefinite beneficiaries and the public benefit requirement 505. The purposes of a charitable trust must benefit society or a sufficiently broad segment thereof such that the trust's performance is of interest to the community as a whole. A. Indefinite number of potential beneficiaries 506. A charitable trust must be for the public benefit generally, or for the benefit of some members of a class of the public that is indefinite in number. 1. Distinguish private trust 507. Unlike a private trust, a charitable trust is valid despite the lack of definite, designated beneficiaries. 2. Enforcement of charitable trust 508. To provide a system for enforcing charitable trusts, because there need not be specific beneficiaries capable of enforcing it, the Attorney General or other public official is authorized to enforce such trusts on behalf of the community. A co-trustee or successor trustee also has standing to sue another or predecessor trustee to prevent or redress a breach of trust or otherwise enforce the trust, as in most states does a person having a special interest in the performance of the trust. Thus, where a particular individual, e.g., the pastor of a church from time to time or charitable institution, is sufficiently identifiable as being entitled to benefit from the charitable trust, that individual or institution may enforce the trust. Under the traditional view of most of the states that have no contrary statute, a settler, as such, does not have such a special interest. But see UTC 405c, the settler of a charitable trust, among others, may maintain a proceeding to enforce the trust. The Attorney General must normally be made a party to proceedings initiated by a trustee or person with a special interest. B. Effect of limited number of direct beneficiaries 5D91. Problems arise where the trust requires the selection of a limited number of actual recipients or where the eligible group of potential recipients is limited. Does the fact that definite beneficiaries will be designated disqualify the trust as charitable? 1. Possible minority view 510. A few dubious and probably outdated cases have held that if only one or a few designated parties would be the direct recipients of the trust funds, the requirement that the beneficiary be indefinite is not met. The trust, therefore, is a private trust, and its validity judged according to private trust standards. Example: a trust to educate some boy or girl in music or art has been held to benefit only one possible beneficiary, and thus to fail as a charitable trust. In Re-Estate of Hubner, 127 Cal. App. 244 1932. 2. Better and General View 511. According to the better view, which is rarely called into question today, a large number or indefiniteness of direct recipients is not essential to a charitable trust. The fact that one or more individuals will become ascertainable as the persons to receive benefits directly from the trust does not make the trust a private one if either recipients will be selected from an indefinite group, i.e., if entry into the limited class of recipients or potential recipients is sufficiently open, and Roman II, the benefit would be sufficiently in the general public interest that the community as a whole could be said to be the ultimate beneficiary of the trust. Rest. 3D 28 CMT. A1J. Example: a trust for the education of a fine child, preferably one who is handicapped, has been upheld as a charitable purpose. In Re Chapman's Estate, 39 Pa. D. and C2D 701 1966. Example: a trust to aid victims of the San Fernando earthquake qualifies as charitable even though the number of actual recipients is limited. Example: a trust to provide educational opportunity or medical care for 2 needy persons from the seniors town selected each year by the trustees is a trust both for the relief of poverty and for the promotion of education or health. Note that a trust of this type can be charitable even if the recipients need not be poor. See Infra 530. Compare A trust for the education of worthy, needy descendants of the settler is private, not charitable. 3. How direct must the benefit to the community be? 512. There are three groups that potentially stand to benefit from a charitable trust. I. The community at large. Roman 2. The direct recipients of the trust funds expended. And Roman 3. The somewhat larger group from which the direct recipients are to be selected. It is immaterial how small the group of actual recipients is. It could even be one individual, provided the category of individuals from which the recipient or recipients are chosen is substantial in size and indefinite in membership. See Scott on Trusts 375-1. 2. It has occasionally been said that the benefit to the community at large must be substantial, and where only a few persons are actually benefited, the benefit to the community is not substantial. Criticisms of this view have suggested that it might mean that a wealthy person can create a large trust that would qualify as charitable because such a trust can make a substantial contribution to the community, while a small trust created by a person of lesser means might not qualify for its inability to make a substantial contribution. Properly, the substantiality of the contribution to the community should be relative to the size of the fund. 2. Effect of trust having non-charitable co-beneficiaries. 513. If a trust has both charitable and non-charitable purposes, e.g., payments to be made in the trustee's discretion to and for the benefit of any one or more of my son, my daughter, or university, or has a purpose that as construed includes, but is broader than charitable, the trust does not qualify as a charitable trust. In other words, a trust cannot have combined charitable and private purposes and still receive charitable trust treatment. It must stand or fall as a private trust. A. Distinguish separate or successive shares. 514. If the trust is so divided by its terms that it may be treated as if it were two separate trusts, or as two separate funds within the trust, or as funds devoted exclusively to a charitable purpose for one period and thereafter to a private purpose, a charitable lead trust, or vice versa, a charitable remainder trust, the amount or interest designated for the charitable purpose university in the above example can qualify as a charitable trust, and the other portion and purpose must stand or fall as a private trust, governed by the more restrictive rules applicable thereto. Example: settler devised property to trustee in trust to pay 1/2 of the income forever to charity, with the other 1/2 to be applied as reasonably appropriate to the support and care of brother. Upon brother's death, the 1/2 principal share from which brother had been receiving the income shall be distributed to brother's then living issue. Here, the independent share that is dedicated to charity will be treated as, and eventually will become, a separate charitable trust. C. Charitable purpose define. 1. Meaning of purpose and charitable in Requirement 515. A charitable trust must have as its trust purpose some activity of such general public interest and benefit as to come within the meaning of the term charitable. As stated above, the qualifying trust purpose or purposes must be exclusively charitable. The charitable purpose cannot be mixed with private or other non-charitable objectives. Rest. 3D28. A. Distinguish motive and purpose. 516. A motive is the reason why the particular settler acted, i.e., it is subjectively what influenced her to establish the trust. The trust purpose is the objective the trust was created to accomplish. It is not the settler's motive that determines the nature or validity of the trust. A court does not care why the settler did what she did, although an understanding of this may be helpful in construing the trust terms and even in determining its purpose. The trust purpose alone determines the validity and charitable or non-charitable character of the trust. Thus, if a trust is actually for the relief of the poor, the advancement of religion, or some other recognized charitable purpose, as described below, it is immaterial why the settler established it, e.g., despite and keep property away from relatives, to reduce or avoid taxes, to salve a guilty conscience, or to gain public approval and influence. Exam tip. It is important to remember that the effect of the gift to the public, or a portion thereof, not the settler's motive, controls. Don't be fooled by a fact situation on your exam, where a school, park, scholarship, etc., created through a trust is required to be named after the donor, e.g., Sarah Smith School. It is still a charitable trust. Likewise, if the settler establishes a trust to build public tennis courts on land adjacent to her home, it is irrelevant that her motive was so she could use them herself. B. What does charitable mean? 1,517. The word charitable is a term of art and encompasses more than relief of poverty, but not everything that a person, or even many people, may think of as good and worthwhile. As we have seen, in addition to the relief of poverty, trusts for the promotion of religion, health, and education, as well as purposes that are governmental or beneficial to the community, are all charitable according to the restatement, UTC, and other traditionally accepted definitions. Other authorities have, of course, used different or additional terminology, e.g., the advancement of the arts and sciences. 1. Limitation 518. In a private trust, gift, or bequest, considerable latitude is given and tolerance exercised with respect to a property owner's freedom to select individual recipients and design their benefits. Similarly, in a charitable trust, society permits property to be committed to an owner's purposes, with that owner's design, and within a less restrictive set of rules than for private purposes, as long as the purpose is one that qualifies as charitable as defined by law. However, other purposes, i.e., those that are neither private nor charitable, are not charitable trust purposes, not even those purposes reflecting motivations that most would consider admirable, and that an individual may pursue while living and still the owner of the property. But see Supra 170. 2. Subjective aspect 519. Basically, the label charitable is a conclusion, meaning that a purpose is deemed in the inevitably subjective views of courts sufficiently desirable and of such benefit to the general public that the dedication of property to that purpose, selected and restricted by one who no longer owns the property, is tolerated even though it does not fit the concepts and comply with the rules applicable to private trusts. 3. Purpose must not be illegal, immoral, irrational, or otherwise contrary to public policy 520. Like other trusts, charitable trust purposes must not be unlawful or contrary to public policy. A trust to promote a cause that is illegal, immoral, or irrational will not be upheld as a charitable trust. But the question of what is irrational is obviously highly subjective. Medical Society v. South Carolina National Bank, 14 SE2D 577 SC. 1941. The third restatement also states that a purpose involving invidious discrimination, which it attempts briefly to describe, is non-charitable and against the policy of trust law, even without a finding of state action. Rest. 3D 28 CMT. F. C. Certainty of purposes 521. The trust purpose, as interpreted by a court if necessary, must be sufficiently certain that the court can tell what the settler intended and Roman II thereby ascertain whether that purpose is exclusively charitable. This should not be understood to mean that the purpose must be narrow or any more defined or certain than the legal concept of charitable itself. The charitable purposes of a trust may be very broad and general. Indeed, the narrower and less general the purpose, the greater the risk of its being found non-charitable. 1. For charity 522. Thus, a trust simply for charity ordinarily will be and often has been upheld as charitable. The language is sufficiently definite to be implemented, as there is no need to determine what specific charitable purposes are not included, and Roman II to make clear that the property is to be applied to purposes that are charitable under the law. In Reestate of Bunn, 33 Cal. 2D 8,971,949. A. Particular charitable purpose need not be specified when charitable intent clear 523. A settler may authorize a designated trustee to select one or more charitable purposes, or the court will, if necessary, appoint a trustee, and either authorize the trustee to select specific charitable applications or determine or frame the specific charitable activity or activities to be undertaken by the trustee. Rest. 3D28 CMT. In fact, bequests to charity have been construed to mean in trust for charity, with a trustee to be appointed. 1. Note: in a few dubious cases, however, trusts simply for charity have been held to be too broad, the court apparently believing that specification of a particular charity or charitable use was necessary to administer the trust. Such a result is not to be expected today. 2. For benevolent purposes 524. Trusts for benevolent or philanthropic purposes may raise some questions and uncertainty because the dictionary meaning of these terms, while including charity, is generally said to be somewhat broader. Example: references to benevolent objects, objects of benevolence and liberality, and the like have been held objectionably broad because purposes that are benevolent are not necessarily charitable. Morris v. Bishop of Durham, Supra 215, the oft-cited classic. A. Modern View 525. Such language today would probably be so interpreted and limited as to qualify as charitable, at least in most states, even if the court recognizes a broader dictionary meaning. Hike v. United States 256 F2D 795 2D Sir. 1958. Wilson v. Flowers 277 A2D 199 NJ. 1971. B. Court may construe trust language as charitable 526. A trust, for the benefit of mankind, has been held charitable, and although a few critics have felt that the expression was either too indefinite or too broad, the varieties of wording that have been upheld show the willingness of courts to construe instruments so as to confine purposes to charitable when needed. This result, however, depends on the interpretation of the instrument and is not a broadening of the definition of charity for purposes of eligibility as a charitable trust. Example: a trust for benevolent purposes would almost certainly fail if the settlor were to say that the term includes but is not to be confined to charitable purposes. However, the fact that an instrument has provided for charitable or benevolent purposes does not preclude a court from interpreting the words as limiting the purposes to those that are both charitable and benevolent, even though this violates the usual judicial admonition that each word is to be given meaning, rather than to attribute redundancy to a testator or donor better than to attribute an intention to create a failed trust. 2. Particular charitable purposes. A. Relief of poverty 527. The relief of poverty is a charitable purpose per se, because the community has a substantial interest in preventing want and suffering. Rest. 3D28 CMT. G. Trusts to provide food, clothing, shelter, and other necessities of life to those in need clearly fall under this heading. Even when the term necessities is used, it is not used in a narrow sense, nor does it exclude comforts that others enjoy. 1. Where non-indigents may benefit as well 528. A trust created primarily to aid indigents or potential indigents can be expected to qualify as charitable, even though it may benefit indefinite non-indigents as well. In this context, the result is not a matter of accepting or retracting the prohibition against a mixture of charitable and non-charitable purposes. It is a matter of defining what constitutes a charitable purpose. Example: a trust for fatherless children is probably permissible as a charitable trust, even though some wealthy children may share, and even though distributions from the trust may relieve the legal duty of supporting such children by mothers who have the means to do so. A. Rationale. The public as a whole benefits from such a trust, which, without being burdened with selectivity, has a tendency, and will have the effect of alleviating poverty within the overall class. V. Warner, annotation, gift, other than one to pension fund, for employees or former employees of a particular business or company, or their families, as valid charitable gift or trust, 51 ALR 2D 192 1957. A court that is unwilling to accept this rationale might find it necessary to construe the language, as has been done in some analogous situations, as limited to those in need because they are fatherless. B. Education 529. A trust to improve the minds of indefinite members of the public is charitable, whereas a trust to educate one's own children is private and, e.g., subject to the rule against perpetuities. This is so whether it involves the support of formal education or of generating or spreading knowledge, information, and culture. This may be accomplished by providing for the establishment or support of schools, colleges, universities, libraries, art galleries, museums, or similar institutions, by aiding students, teachers, or research activities within or outside educational institutions, as long as in the latter case the purposes are the advancement of knowledge rather than increasing the profits of a particular concern, or by the publication and distribution of books, although some question exists in some jurisdictions whether the purpose is educational or otherwise charitable, when the books are limited to the support and promotion of particular views or particular objectives. Rest. 3D 28 CMTS. H. L. But see Planned Parenthood League v. Attorney General, 464 NE2D 55 Mass. Cert. Denied, 469 U.S. 858 1984. Dissemination of propaganda supporting Planned Parenthood held a charitable purpose. 1. Need not benefit the poor. 530. An educational trust need not involve relief of poverty to be charitable, because the acquisition and spread of knowledge per se is beneficial to society. Generally, however, funds cannot be granted to profit-making institutions in an unrestricted fashion that is calculated to increase profits. However, there is no obstacle to such institutions holding or receiving funds that are restricted to use for charitable purposes within the sphere of their activities. 2. Profit-making institutions. 531. A trust created simply for purposes of education has been held non-charitable because it was not limited to non-profit educational institutions, the profit-making purposes not being charitable, as discussed in more detail below. In Re-Estate of Sutro, 155 Cal. 727-99. A. Court may construe trust language as benefiting only non-profit institutions. 532. This construction is unwarranted. Many courts have been willing to construe SU-H dispositions so as to avoid the profit defect by implying that only non-profit institutions can benefit. Butterworth v. Keeler, 219 NY, 446 1916. B. Tuition must not be used to make a profit. 533. The fact that tuition is charged by a school for which the trust is created does not prevent the trust from being charitable. The education need not be free, but the fees charged must not be for the purpose of making a profit, i.e., must not be for the purpose of earning dividends for investors, as opposed to merely meeting expenses of or improving the school's operations. C. Profit makers as incidental beneficiaries. 534. Nor would it affect the charitable character and validity of a trust for education or scholarships if the trustee were to send the persons to be educated under the trust to a private school, probably even a profit-making school, or even if the trustee were to hire private tutors. The cost of private schooling or tutors profit makers would merely be expenses of the trust, and its administration the incidental beneficiaries not being encompassed within the purposes of the trust, and having no status to enforce it. 3. Politics and change of law. 535. Trusts to disseminate particular political views or beliefs have not always been upheld, but in most jurisdictions today, these probably would be upheld as charitable under the heading of educational. It is not important whether the views are popular ones, as long as some substantial group of persons is interested in the views and ideas, as distinguished from views that are irrational or virtually unique to the particular would-be settler. A charitable public interest appears to be recognized not only in the protection of dissident views and beliefs, but also in stimulating the marketplace of ideas. Rest. 3D28 CMTS. H.L. A. Political Views 536. Although the questions of whether, to what extent, and in what instances support of particular political views or beliefs compare infra 539 will be upheld as charitable has no doubt varied from place to place and from time to time. The trend appears to be to uphold such activities as charitable. See, e.g., in Re Estate of Breedon, 208 Cal. App. 3D 981 1989 Trust to Advance Principles of Socialism upheld. But see in Re Shaw, Supra. 172 Trust to support study of advantages of phonetic alphabet, to publish and distribute books in this alphabet, and to fund campaign for alphabet's adoption, held not charitable in England, but an unlikely American view. Also compare Jackson v. Phillips, 96 Mass. 539 1867 Trust to create sentiment to end slavery upheld, with Bowditch v. Attorney General, 134 NE, 796 Mass. 1922 Trust to promote women's suffrage, not upheld. See Infra, 538. B. Particular political party 537. A trust to promote a particular political party is not considered to be charitable, however, because there is no public interest in subsidizing one political group over any other. Rest. 3D28 CMT. L. C. in Re Grossman's Estate, 190 Misc. 521 1947. C. Change in Law 538. Clearly a trust for the general improvement of the law, e.g., to support the work of the State X Law Revision Commission, is charitable. But trusts to bring about a particular change in the law may or may not be. Example: trusts to bring about changes in the law or form of government through legal means, sometimes including lobbying, have been upheld as charitable. Gerard Trust Co. v. Commissioner of Internal Revenue, 122 F2D 108 3D Sir. 1941. 1. Note: under federal income and estate tax rules, groups significantly engaged in lobbying are not qualified charitable organizations for tax purposes. If a trust is not charitable under state law and therefore fails, the attempted transfer to that trust will not receive charitable tax treatment. However, the mere fact that a trust is charitable under trust law does not assure its treatment as charitable for tax purposes, nor is the fact that a purpose is or is not charitable for tax purposes controlling for purposes of validity or invalidity under state trust law, although a state court may be influenced by tax policy in these matters. See Religion 539. A trust for the maintenance and support of religion by providing for religious services, places of worship, salaries and maintenance of religious workers, religious education of youth, and other similar objectives is generally held to have a valid charitable purpose per se. Even a trust created simply for religious purposes chosen by my trustees should qualify. Rest. 3D28 CMT. I. 1. Masses. A majority view 540. In most states, trusts for the purpose of having masses said for the soul of the settler or others are upheld today as valid charitable trusts deemed to benefit indefinite interested members of the public through religious exercises. Webster v. Sugro, 45A, 139 NH, 1898. B. Minority view 541. A few decisions are contra, holding such trusts are intended only to promote the memory or benefit of a particular decedent, and hence lack sufficient public or religious benefit. Festrezzi v. St. Joseph's Catholic Church, 18 so. 394 ele. 1894. C. Trust may be honorary, if not charitable 542. Even if such a trust were invalid as a charitable trust, its purpose might be allowed to be carried out through an honorary trust. See Supra, 170, or, if the named recipient of such a bequest were willing, as a mere precatory request as to its disposition. See Harrison v. Brophy, 51 p. 883 can. 1898. 2. What constitutes religion? 543. The usual problem in the limited number of religious charitable trust cases is that of what constitutes a religion or a religious purpose. A trust for any religious doctrine or group is likely to be upheld if there is any substantial interest in it at all, and not essentially peculiar to the particular settler. There being a public interest in religious freedom and tolerance, with practically any doctrine having some followers throughout the community being recognized. BBB. Annotation. Validity of trust for religious purposes, not limited by sect or denomination. 22 ALR 697 1923. A. Irrationality 544. Some cases have caused difficulty when trusts are established to support beliefs that are deemed so irrational or inconsequential as to be of no community interest. Line drawing can be difficult, as it has been in cases involving spiritualism. B. Illegality and immorality 545. Sex advocating or engaging in illegal or immoral practices have been held not to qualify. Potter v. United States. 79F. Sub. 297 ND. Ill. 1946. See Atheism 11546. Courts have frequently attempted to define religion as a belief having some recognition of a supreme being. Thus, a trust to promote atheism might not be recognized as a religious charitable trust, although it could well be sustainable as one for education, marketplace of ideas, etc. D. Health 547. The cure of disease and promotion of health, including relief from pain, are charitable objects per se. Rest. 3D28 CMT. J. Examples. Trusts to maintain hospitals, encourage medical research and education, etc. are charitable. Sheen v. Sheen, 8A2D 136 NJ, 1939, as are trusts to improve the condition or to provide for the care and treatment of the blind, disabled, etc. 1. Non-indigents may benefit, but no profit purpose allowed. 548. As noted in connection with education, see Supra. 530-534. The trust need not be for the benefit of impoverished persons who are unable to provide their own medical care. But, again, funds that are provided to hospital institutions and the like must not be for the purpose of enhancing profit-making. E. Purposes that are governmental or beneficial to the community. 549. A trust for governmental or municipal purposes will be sustained as a charitable trust because there is clearly a general community interest in the functioning and activities of government. The beneficiary of such a trust is the public through the governmental body, e.g., city, state, etc. Similarly, a trust for the promotion of other purposes that are beneficial or of widespread interest to the community is charitable. Rest. 3D28 CMTS. K.I. Examples. The following have been held to be charitable purposes: relieving taxpayers from the burden of supporting government, constructing and maintaining public improvements, buildings, and institutions, providing parks and playgrounds, and apparently encouraging patriotism. Pearce v. At Will, 125 NE, 609 Mass. 1920. The promotion of arts and culture within the community also is charitable. See also Supra. 529. 1. Animals. 550. It is also charitable to prevent suffering and want on the part of indefinite groups of domestic or wild animals, or to prevent cruelty to them. But gifts to maintain particular animals, e.g., my dog, Rover, are not charitable, nor are they private. But see Supra, 170-176. Charitable trusts to provide for stray animals or to support a local humane society could as well fit under Health Supra, 547. But they are generally sustained as of benefit or interest to broad segments of the community and as a relief to governmental resources. In any event, it is clear that such trusts fit somewhere within the charitable categories. And it is worth noting through this example that purposes listed as charitable are not always precise. nor are they mutually exclusive. 2. Political changes 551. A trust to bring about improvements in government through orderly constitutional or statutory change is charitable. See Supra 538. But, as noted previously, a particular, specified change believed in by the settler may in some jurisdictions raise difficulty. And certainly the advancement of a particular political party is generally rejected as a charitable purpose. See Supra 537. A.S. Klein, annotation. Validity of charitable trust to promote change in laws or systems or methods of government. 22 ALR 3D 886 1968. 3. Other charitable and non-charitable purposes 552. According to the third restatement, dicta in cases and observations of commentators, charitable trusts may also exist for other objectives that are difficult to define precisely, e.g., as mentioned Supra 549, other purposes, the accomplishment of which is beneficial to the community, and other specific purposes that have not been mentioned and may be difficult to categorize. Clearly, however, not every kindly purpose is charitable. A. Subjectivity 553. A settler may believe he is leaving his property to a worthwhile cause that he deems to be charitable. But the settler is not the final judge of what is of benefit or interest to the community. The charitable purpose must be one designated as such by law, but, apart from legislation, this must be decided by a human being or panel of human beings who make up a court. The judges may obtain aid from the testimony of experts and the like. But ultimately, what is of benefit or interest to the community depends on a process that makes precise definition a difficult matter in marginal cases. B. General Standard 554. The standard, nevertheless, remains one of benefit to the public or indefinite members thereof, if the purpose of the trust at its creation is not a charitable one within this definition. A trustee's promise to limit herself to charitable purposes does not save the gift. C. Some examples of other purposes. 1. Care of graves 555. Trusts for the perpetual care of graves, although once in substantial doubt, are now generally upheld as charitable. See in Reestate of Gay, Supra 172. Care of graves in public cemeteries should be upheld as beneficial to an attractive community, even without legislation. A. Statutes 556. Such trusts are often expressly permitted by statute. See, e.g., NY, EST, Powers and Trusts, Law 815-16. B. Religious 557. If not viewed as meeting the general standard of beneficial to the community, even many non-public cemeteries may be upheld as religious in nature, so that a trust for the erection and care of graves might qualify in the religious category. C. Honorary Trusts 558. Finally, in some jurisdictions such gifts may be carried out for a limited time by willing trustees as honorary trusts. See Supra 170. 2. Senior Citizens 559. In contrast, trusts for older people or for the elderly, not necessarily indigent, may be kind and well meant, but have occasionally been held not to fit under any of the specific categories previously mentioned, and not of sufficient benefit to the community as a whole to qualify under the more general charitable characterization. A. Health or relief of poverty 560. Other cases, however, are clearly contra. See, e.g., in Reestate of Tarrant, 38 Cal. 2D 42 1951. Such a trust can also be sustained as one to promote health, particularly if it is to house or take care of elderly persons, or as one for relief of poverty, either by construing the trust as confined to or by concluding that it is primarily for those in need. See the fatherless children example Supra 528. See also Rest 3D 28 CMT J. 3. Other non-charitable purposes 561. The following have also been held to be non-charitable purposes: aid to private social clubs or lodges, but some fraternal and like organizations may serve primarily charitable functions, and providing for the care of inanimate personal property, for homes or estates, for the preservation and display of the settlers' collections or creations, or for the erection of statues or monuments or the like where there is no real public interest in the particular person's life or activities or in the perpetuation of that person's memory. A. Distinguish historical or artistic merit 562. On the other hand, collections or homes can be of public interest for historical reasons or because of peculiar qualities. Trusts to collect, maintain, and display, e.g., the artwork of a particular individual, may be charitable if the artwork has substantial artistic merit, or if it is the work of an important historical figure, such that in either event there would be a public interest in it, and thus a public benefit to be derived from it. The mere fact that an individual is prepared to fund such activities does not mean that a charitable trust can operate to display the art collected or produced by that would be senior on the merits of which expert testimony is receivable. In Re Pinion, 1965 1 ch. 85. D. Qualification as a private trust 563. If a particular trust purpose fails as a charitable purpose, the trust may nevertheless qualify as a private trust. As such, it is subject to ordinary trust requirements of definiteness of beneficiaries, and of the rule against perpetuities and related doctrine see supra. 241 et seq. 1. Note: if the trust likewise fails as a private trust, and is not an honorary trust see supra. 170, it will be held upon resulting trust for the settler or his successors in interest. Exam tip: keep in mind that the categories of charitable purposes are not mutually exclusive. A specific trust purpose may fit under multiple charitable categories. For example, a trust for the promotion of temperance in the use of alcohol or other addictive substances may involve education or governmental services, promote health, and contribute to the general quality of life within the community. But don't spend too much time trying to identify every possible charitable purpose. As long as the trust purpose meets the standards of at least one of the charitable categories, it will be upheld as charitable. 4. Profit-making or private purpose, not charitable 564. The trustee of a charitable trust need not be a charitable organization. The trustee may be, and often is, a profit-making concern, e.g., a bank or an individual, as noted in connection with specific charitable purposes above. However, the trust purposes must not be to benefit a profit-making organization, even if that organization functions within one of the areas normally associated with charitable activities, e.g., health, education, and in particular, because profit-making organizations can administer charitable trusts in connection with their own operations. The funds must not be used for profit-making, but must be used for the exclusive benefit of a charitable purpose, just as they are so used by banks and other profit-making concerns that administer charitable trusts. What is crucial is that the trustee must be absolutely limited to expending the trust funds for nonprofit, charitable purposes. A. Segregation of trust funds 565. If there is any possibility that the trust funds may validly be used for profit-making purposes, for the personal gain other than proper compensation of the trustee, or for any other private purpose, the trust cannot qualify as charitable unless the funds that may be so used, i.e., those that do not qualify as charitable, are separated out by portion or by time see infra from those that are solely and exclusively permitted to be devoted to charitable purposes. And, again, remember that the trustee cannot save a trust with a purpose that is broader than charity by promising to dedicate the funds strictly to charitable purposes. The failed disposition causes a resulting trust, so that the trustee cannot declare a new trust. B. Split interest trusts 566. Just as a trust can be divided in quantum, i.e., by share or portion between charitable and profit-making or private purposes, a trust does not have an objectionable mixing of purposes where property is to be devoted exclusively to private purposes for one period of time and exclusively to charitable purposes for another. These split interest trusts are common today in the form of charitable remainder trusts, e.g., to T in trust, to pay $30,000 per year to L for life, and on his death to university, or charitable lead trusts, e.g., to pay $30,000 annually to university for 20 years, principal then to X or her issue. C. Incidental benefits 567. Despite these strict rules, a trust may be a charitable trust despite an incidental benefit that may accrue to the trustee. MC. Dransfield. Annotation. Effect on certainty of purpose or beneficiaries of a charitable gift, of the possible, but not required, inclusion of a non-charitable object. 115 ALR. 123 1938. 5. Conditional gifts to charity 568. If conditions attached to the charitable interest require that the property also be devoted to a non-charitable purpose, e.g., provided the trust employs me as an advisor at $25,000 per annum, the trust is not charitable under trust law. See Scholarship Endowment Foundation v. Nicholas, 25F. Sup. 511d. Colo. 1938. Compare Supra. 566. A. Settler's Name 569. A condition that the fund, endowment, or activity, etc., created and supported by the trust be named after the settler, e.g., the John Smith Foundation, does not detract from the charitable status of the trust. Any such benefit would be incidental. B. Conditional amount 570. Nor does it preclude a charitable purpose that the amount of the gift is conditional, such as where matching funds from other donors are required, e.g., a trust to pay $1,000 to university for every $1,000 it raises from other sources. D. Limitations on charitable trusts. 1. Charitable limitations or Mortmain Acts 571. Few, if any, states still have legislation invalidating or restricting amounts that may be left by will to charity, especially last-minute gifts. These statutes, sometimes imprecisely referred to as Mortmain Acts, after the early legislation in England restricting ownership of land out of concern for the power of the Church, invalidate or limit gifts by will to charity in various ways. See Will's summary. These are reviewed here because of the possibility of a revival of their popularity and what past experience may teach. A. Types of limitations 572. Such a statute may simply limit the total amount that can be left to charity, e.g., 1/3, especially if the decedent is survived by certain close relatives who would otherwise inherit, or may provide that bequests and devises to charity in wills executed within a brief period of time prior to the testator's death, e.g., 30 days or 3 months, are entirely void. A statute might also contain some combination of these approaches. B. Not applicable to inter vivos trusts 573. These statutes have generally applied only to transfers by will, and not to property passing under an inter vivos trust. Even if the trust was executed shortly before the settler's death, Citibank Farmers Trust Co. v. Charity Organization Society, 238 AD, 720 1933, or the decedent retained a life interest and power of revocation, Scott on Trusts 57.5. C. Secret Trusts 574. This type of legislation applied not only to testamentary trusts, those expressing the charitable purpose in the will, but also to constructive trusts for charitable purposes imposed based on an oral promise on property passing by will. Example: shortly before death, testator executes a will devising Blackacre to friend in reliance on friend's oral promise that she will hold the property in trust for church. Upon friend's refusal to perform her promise, a constructive, secret, charitable trust would normally be imposed, but, to the extent it falls within a statutory limitation or restriction, the statute would apply to invalidate the gift in re Sturk's estate. 81A. 187 Pa. 1911. D. Charitable Corporations 575. Related legislation of this type applied only to gifts to charitable corporations. 2. Charities and the rule against perpetuities. A. Duration 576. A charitable trust may be created to continue perpetually. The common law rule against perpetuities does not apply to the duration of charitable trusts. Rest. 3D29 CMT. G2. B. Vesting of gift 577. The rule does apply, however, to the vesting of a charitable gift later than lives in being plus 21 years. Similarly, a shift from a charitable purpose to a private purpose that may vest later than the period allowed by the rule is also invalid, although the prior interest to charity would be unaffected. See Supra 247. C. Change of charitable beneficiary or purpose 578. The interests in or benefits of a charitable trust can shift from one charity to another charity at any time, even after the period of the rule against perpetuities has expired. Thus, it is sometimes said that the interest need only vest in charity within the period. But it does not matter that the particular charitable beneficiaries or purposes shift thereafter. Exam tip. One of the key differences between private and charitable trusts is that, unlike private trusts, charitable trusts may be perpetual, i.e., can last forever. There is no objection to shifting the benefits of trust property from charity to charity through time, e.g., to T in trust for a charity for 100 years, then to B charity for 100 years, then to C charity for 100 years, etc. This is known as the charity-to-charity exception to the rule against perpetuities. Thus, if your exam question involves shifting among only charitable purposes, you need not consider the rule. However, you are more likely to encounter a fact pattern where the gift shifts from a private to a charitable use, or from a charitable to a private use. Then you must think about the rule. See Supra 240 at Sec. 3. Constitutional limitations on charitable purposes 579. Constitutional limitations on state action may also affect charitable trusts in certain situations. For example, state action may not require or further racial discrimination. Thus, to the extent a trust involves state action, racially discriminatory provisions are unenforceable under the Equal Protection Clause of the 14th Amendment to the United States Constitution. The troublesome question is when state action is involved. A. State agency as trustee 580. A state agency may not serve as the trustee of a trust that involves racial or other prohibited discrimination. Pennsylvania v. Board of Directors of City Trusts, 353 U.S., 230 1957. B. State as prior trustee 581. A trust may become so tainted with state action as to render such discriminatory provisions unconstitutional, e.g., a trust once publicly administered, but thereafter administered by a private trustee, as a result of the facts and history, had become so intertwined with the state as to render its administration a continued form of state action. Evans v. Newton, 382 U.S., 296 1966. Pennsylvania v. Brown, 392 F2D 123D Sir. 1968 further litigation involving the Girard College Trust for poor male white orphans that was involved in Pennsylvania v. Board of Directors of City Trusts, Supra. C. No Public Trustee 582. Where a public agency does not and has not served as a trustee so as to provide state action in that manner, it remains uncertain whether state action is so inherently a characteristic of all charitable trusts today via the State Attorney General's duty and power of enforcement, state and federal tax immunities, and various other special privileges not available to private trusts, that a charitable trust is by its very nature a form of state action precluding discriminatory provisions and their enforcement. See Bank of Delaware v. Buxton, 255 A2D 710 Del. 1969. In Re-Estate of Wilson, 59 NY 2D 461 1983. And see cases cited Supra, 580-581. However, regardless of state action, public policy under state trust law may invalidate trusts or trust provisions that involve invidious discrimination. See Supra, 520. An easy way to distinguish private, charitable, and honorary trusts is to look at the beneficiaries and trust purpose. A private trust must be for the benefit of one or more identifiable beneficiaries ascertainable within the rule against perpetuities, and for any purpose not against public policy. Charitable trusts must benefit indefinite beneficiaries and only charitable purposes. An honorary trust has no beneficiaries capable of enforcing the trust and no charitable purpose. Modification of charitable trusts, the Cypres Doctrine. 1. Nature and requirements of Cypres 583. Because a charitable trust can be created to last indefinitely, see Supra 576. It occasionally happens that a trust outlives or outgrows the particular charitable purpose for which it was created. The doctrine of Cypres may then be invoked by the court to modify the trust, i.e., to apply the trust funds in a manner as near as may be to the settler's plan. Thus, the Cypres Doctrine is the law's basis for deviating from the trust's original purpose or opposes and modifying them to fit current circumstances. If the court finds that permissible, rather than having the property revert by resulting trust to the settler or the settler's successors in interest. Requirements 584. To invoke Cypres, the court must find the following. 1. Designated purpose fulfilled or frustrated 585. First, the particular charitable purposes specified by the settler must either be fully accomplished without exhausting the trust estate, or have become illegal, impossible, or at least impracticable, or, in the case of excessive funds, wasteful to carry out. But it is not sufficient merely to show that some other purpose might be preferable. 2. Settler had general and not restricted charitable intent 581 second. It must appear that the settler had what is usually called a general charitable intention, i.e., it must not appear that the settler intended to limit her gift, absolutely and regardless of unanticipated circumstances, to the specified charitable purpose or purposes. The doctrine is intended to implement, not undermine, the settler's intentions. This requirement is eliminated unless the trust terms expressly provide otherwise. Under the third restatement and the UTC, Rest. 3D 67, UTC 413. B. Result apply funds to similar purpose 587. Where the above factors are found to exist, the court, exercising its general equity power of Cypres, will direct application of the trust estate or excess portion thereof to some charitable purpose that is as similar to the designated purpose as circumstances allow, and as would be consistent with the settler's probable intentions, or that reasonably approximates the designated purpose. Rest. 3D 67 CMT. D. 2. Application of Cypres 588. It is not sufficient to find that, as circumstances have developed, a better purpose for the trust funds can be found. The mildest term used by most courts, and by the third restatement and the UTC, is impracticable, a more demanding term than impractical or inexpedient, although the latter term can be found in at least one statute. In addition, a general charitable intention must be found under the traditional view, because application of Cypres supersedes the normal principle of resulting trust, under which the property or interest would revert to the settler or her successors in interest. Note that general charitable intent is not necessarily precluded by a provision directing application only to the stated purpose, for this language found in many instruments is likely to have been used without anticipating the circumstances required for a Cypres case. But if it is found that the settler would not have wished any modification of her purpose, under the traditional view, then the court must not apply the doctrine. A. Where trust would otherwise terminate 589. Even though the circumstances would otherwise justify or cause a termination of the trust, with a resulting trust arising, see infra 1011 WD 20. The courts may intervene under this doctrine to modify the trust, so as to continue it in effect, as long as this is consistent with an underlying general charitable intent of the settler. B. General vs. Restricted Intention 590. A further examination of this question is important because si pres is to be applied only where consistent with the probable or legally presumed wishes or reasonably attributed intention of the settler. See Supra 586. 1. Expressed gift over if purpose fails 591. Where the settler has provided a valid express gift over in the event the designated trust purpose fails or the funds become excessive for that purpose, there is very little room for the si pres doctrine. In fact, if there is an effective gift over to another charity, the trust's designated purpose does not fail. A. Rule against perpetuities 592. This, of course, assumes that the gift over is valid and effective, e.g., not precluded by the rule against perpetuities as a private purpose would be if the interest, as created, could vest later than the period of the rule. Green v. Old People's Home, 109 NE, 701 IL, 1915, but a remote gift over to another charity is valid without concern for the rule. In Levin's estate, 171A, 617 Pa, 1934. B. Resulting trust 593. If si pres is not applicable and the gift over fails because of the rule against perpetuities or otherwise, a resulting trust arises for the settler or her successors in interest on failure of the charitable purpose. 2. Restricted charitable purpose 594. Si pres also cannot be invoked where the settler apparently intended only to benefit a particular charity or charitable purpose, which has now failed. If it is expressly provided or under traditional doctrine, found that the settler not only intended to confine the trust property to a particular charitable purpose as long as it can be carried out, but further intended that the trust terminate if it can no longer be applied to that purpose. A. Tendency to construe trust purpose as non-restrictive 595. Courts are usually reluctant to find the senior's intention so restrictive, especially if the trust has been in operation for a long time, because a resulting trust ordinarily would constitute a windfall to those who would take under it. Hence, as indicated earlier, even a statement in the trust that the settler intended the benefits to flow to charity and to no other purpose often means so long as practicable and does not prevent application of the doctrine. City of Aurora ex rel. Egan v. Young Men's Christian Association, 137 NE2D 347 IL, 1956. B. Where trust fails 596. It may appear or be expressed, as required by the third restatement view, that the settler had only a limited charitable purpose in mind, and would have preferred the whole trust to fail if that purpose cannot or can no longer be carried out. In such cases, si pres does not apply in the absence of contrary legislation requiring a valid express gift over, and the trust must terminate and the property will revert. Example: settler bequeathed property in trust for the operation of here discriminatory basis. In light of the particular facts, the court held that gift si pres could not be applied. The trial court found under the traditional view, with the Supreme Court declining to invalidate the finding that settler was so opposed to integration that to apply si pres to remove the racial restriction would have violated his intentions. Evans v. Ebnai, 396 U.S., 435 1970. Compare. On the other hand, a devise in trust to establish a home for aged white men was modified to delete the term white, where continued racial discrimination would be unconstitutional, and the court believed that the settler was more interested in helping aged men than helping white men only. Wooten v. Fitzgerald, 440 SW2D 719 text. 1969. Might the gender restriction stand today or elsewhere? See Supra, 520. Compare Ebbets v. Pioneer National Bank, 361 NE2D 225 Mass. 1977. Within Re-Estate of Wilson, 59 NY2D 461 1983. And see Trustees of University of Delaware v. Jebeline, 420 A2D 1D 1 Ear 91 Del. 1980. Women only sustained partly on affirmative action grounds. C. Frustration of purpose 597. Courts are also reluctant to find a failure of the trust's original charitable purpose. The usual test of cypres is a severe one as noted before, requiring more than inconvenience or a preferable purpose. Salvation may be found in a broad interpretation of a specified purpose, and certainly a mere breach or failure by the trustee to carry out the designated purpose is not enough if the purpose could be carried out by a more willing and determined trustee. In Re Mead's estate, 279 NW, 18 Wise, 1938. D. Nearest purpose 598. Once it is concluded that cypres is to be applied, the court must modify in such a way as to approximate, some might still say as nearly as reasonably possible, the original purpose or the settler's probable intention. Case results suggest it is proper to consider as a settler probably with the degree of community benefit along with the degree of proximity. Example: George Scott left funds in trust to St. Thomas Church to erect and maintain a hospital for persons suffering from tuberculosis, to be called the Scott Memorial Hall. Upon finding that special hospitals were no longer required for the treatment of tuberculosis, and that the funds were inadequate to erect and maintain an appropriate building, the lower court directed that a fund be established for the care of persons suffering from similar disorders. This application of cypres was reversed and remanded on appeal, the lower court being directed to apply the doctrine to show appropriate respect for all three discernible purposes of the settler: a building in his name, to be erected by St. Thomas Church, to aid tuberculosis patients. Finn re Scott's Will, 8 NY2D 4 1960. One comment: sometimes it is possible only to speculate about the best modification when a number of reasonable and close alternatives are available. Extrinsic evidence may or may not be illuminating. Exam tip: a common theme throughout this chapter has been that charities are favored by the law. Thus, if you encounter a charitable trust on your exam that appears to have outlived or outgrown its original purpose, remember the cypres doctrine. First, you must determine whether the charitable purposes have been fully accomplished or have become illegal, impossible, impracticable, or wasteful to carry out. If some valid purpose remains, even if a better purpose can be found, the trustee must continue to carry out the original purpose. However, if the original purpose fails, and under the traditional view, if the settler had a general charitable intent, a court will direct that the trust property be applied to another charitable purpose that approximates the settler's probable intent.